as an analogy, and it goes like this. Dawn follows dawn and the night grows old, and all the while this cat lies crouching on the Chinese mat with eyes of satin rimmed with gold. Get hence thee loathsome mystery, hideous animal, get hence, thou waketh me each festinous sense. You make me what I would not be. You make my creed a barren sham. You wake foul dreams of sensual life. And that was penned by Oscar Wilde. And I've read that poem. And I think the more you read it, the more you're left scratching your head because it just doesn't really make any sense. Nor did Oscar Wilde's life, apparently to him, when he searched it for meaning and purpose, which led to his sad demise. And there are some things in life that just don't make sense. And by way of analogy, this case is sort of like that poem. We search for meaning, we search for purpose. We look under the covers, we look at the parameters of the law, and oftentimes, unfortunately, we end up with more questions than the law provides answers. Here's a case where my client contends that he shot and killed his mother in self-defense. He states that she came up and she lunged at him, and he felt threatened and shot her intentionally, but in his mind, in self-defense. Well, there's a dispute that, except for testimony of the sister, who basically says that her mother did not lunge at my client. So it's his word against her word when it comes to that. A lot of the other things are not in dispute. There is a dispute about whether he shot at his sister in the hallway. The defense would contend there's insufficient evidence to establish either way where that shot was fired. And there's also insufficient evidence to show that my client's sister was in reasonable apprehension of being grievously injured bodily or killed when a shot was fired. There's questions as to that, but I want to focus my closing argument mainly on the bigger of the charges, which concerns the allegation of murdering his mother. My client says that this is self-defense. So how do we look at self-defense through the lens of somebody who believes that his mother was poisoning him, despite the fact that there's no evidence of that? How do we look at self-defense or consider a lesser included charge of voluntary manslaughter, possibly, in a scenario where the defendant also claims that he's being poisoned by the Fulton County Jail, despite the fact that there's no evidence of that? How do we look at self-defense? How do we look at voluntary manslaughter through the lens of someone who operates with that mentality? It's sort of like a ship going down a stream surrounded by fog, where you just can't see where you're going to end up. So my argument, my principal argument, is that we need to look at the law in a way that allows us to be flexible in how we interpret it and how we apply it to a given scenario. That isn't to say that we should apply the law and interpret it through some existential lens. But what we need to do as a society is recognize that not everyone sees things the same. The lens through which my client sees reality, I would argue, is different than the lens through which many other people would see reality. In his mind, he felt threatened. In his mind, he felt he was being poisoned. In his mind, he believes he's still being poisoned at the Fulton County Jail. Here's a case where the state's evidence mainly just consists of the say-so of my client's sister. The other individual who was involved in this case, Gregory Perez, for reasons we don't know, did not testify. For whatever reason, he either chose not to testify, or maybe the state couldn't find him, but there was no testimony concerning why he didn't testify. Obviously, Beverly Headspeth can't testify because she's no longer here. We did not hear from the two children, Cameron and Fabian, who are also listed as alleged victims in the indictment. We have no explanation from any of the state's witnesses concerning why three principal witnesses in the state's case, also listed as victims in the case, did not testify when it comes to shedding some light on a case which I would argue provides us with more questions than answers. Ultimately, the state has the burden of proof. The state has to prove beyond a reasonable doubt that what my client did was not self-defense, given that he has made this defense, this assertion. So the defense contends, Your Honor, that if we were to apply the law flexibly and not inflexibly, if we look at the principles of justice and the principles of law, the only rational conclusion that we can make is that the state has failed to prove beyond a reasonable doubt that my client is guilty of any of the counts set forth in the indictment. So I'm asking Your Honor to find my client not guilty. Thank you.
Thank you, Your Honor. Your Honor, the state has proven beyond a reasonable doubt the charges in this indictment, and the state's going to focus on as this honorable court is well aware, the testimony of a single witness, if sufficient, is enough to establish a fact. In this case, you have two witnesses, primarily Vernice Headspeth and the defendant's own words, that through both of those almost exclusively establish the elements necessary for the charges in this indictment, which is more than sufficient to legally convict. An overview of these charges, Your Honor, and the state's going to start with the first charge in this indictment, which is murder. I know this honorable court is well aware of murder and legal principles, but just to couch this argument, we'll start with those because those are what the state must prove beyond a reasonable doubt. And with murder, you have to have malice forethought that unlawfully causes the death of another person. In this case, the defendant's mother, Beverly Headspeth. And his actions, as the evidence expressed, show that there was a deliberate, there is express and there is certainly implied in this case, given his actions before, during, and after the shooting of his mother. And there was no legal justification for those actions. And although it does not require premeditation or motive, the state argues that the evidence shows both of those exist. And the primary evidence for the causation, Your Honor, is captured in this slide. State's Exhibit 55 is an autopsy photograph that shows the entry wound through Miss Beverly Headspeth's nose. That is the projectile that 9mm shell casing that Jay Jarvis testified came from and had characteristics consistent with coming from the .40 caliber handgun, which is State's Exhibit 47, that the defendant gave to Sergeant Watkins when he was arrested. And as Dr. Sullivan testified, the Fulton County Medical Examiner, the cause of death was a gunshot wound to the face, and the manner of death was homicide. I had asked Dr. Sullivan, and she testified she did not believe there was any other contributing factors to Beverly Headspeth's death, and these actions were directly caused from the defendant within 1 to 3 feet, based off the stippling, discharging a firearm at his unarmed mother. These two crime scene photographs capture the crime scene of where this happened. The context of this was a motel room, a bedroom where they were living and staying for a month. And the only weapon that was ever testified about was the weapon that the defendant had, the loaded .40 caliber. And State's Exhibit 21, as Vernice walked through, Miss Beverly Headspeth was in that far bed sitting by the pillow, and Gregory Perez was on the end when the defendant is the first person to pull out the firearm, pointed at Gregory Perez, and that started as the initial aggressor, all of the subsequent actions of the defendant. And these are the bloody clothes and pillows after Beverly Headspeth was shot, where she was situated when law enforcement and EMS arrived. The state would like to focus on a brief clip of the defendant's interview with Detective Williams that gives some insight into his thought process that goes to the malice in this case.
Like do the right thing. So what happened was she She did that. So I laid down, I was thinking about it. I'm like, I was just so eager about the situation. And then, so I was like, I'm gonna wait for my sister to come and I'm gonna.
Really hear that at all?
Yes, Your Honor.
You know what I mean?
Your Honor, what? Your Honor, what do you? No.
This could be your laptop.
Yes, Your Honor. Or what he talks about, and I know that the court has reviewed this statement, is that he was thinking about it, that this happened around 1 or 2 p.m. when he first had the belief that his mother was poisoning him, and he contemplated. He was heated about the situation. He was angry about this. It was something that had been going on in his mind for up to a year. And the time he spent, he brought the loaded firearm when he walked away from the hotel, came back. He actually stated he wanted to wait for his sister to get there so that she is there when he wanted to confront both Gregory Perez and his mother. He mentions in here as well that he could not prove he was attacked. He actually took the steps to look up self-defense on, and he didn't have enough evidence to bring it to the police. So he contemplated other actions that he could have done. And this shows that he had contemplated confronting them, which resulted in him shooting his mother in the face long before that transpired around 3:00 p.m. And those are very significant facts.
Like, do the right thing.
Furthermore, Your Honor, there is a number of inconsistencies between his statement and what was testified at trial. And these are some of the key salient points that the state wants to walk through. In his interview statement, he does not mention at all his mother grabbing his shirt. He just mentions her coming, cussing at him, standing up from the bed after he had pulled out the firearm and pointed at Gregory Perez. And he thought, in his words in that statement, that she lunged at him. But at trial was much different. He mentioned some additional shootings that none of the other evidence or witness in the case discussed. And he mentions a time after he pulled the firearm out where Gregory Perez, Bernice Headspeth, and his mother are all sitting on the same bed on the far left side. And he actually discharges a firearm where he says it struck Gregory Perez. That testimony is in stark contrast to Detective Williams, who testified interviewing Gregory Perez, who in the police station, within less than an hour after this, he clearly was not shot. And the defendant's outline of events is in stark contrast to the other evidence, and therefore it should not be believed. Furthermore, he testified about it after he's in the hallway and takes Bernice Headspeth's phone, that he shoots when he thought either hit the door, which did not occur in terms of East Point Police Department, the crime scene photos show no bullet in that door, or it went inside. And he mentioned one of the children opening the door, which from his version of events would show he shot a firearm into a room where the children were at. But I don't think that that shot ever even happened. And the reason that you know that is because Bernice testifies that she blacked out and realized once officers were on scene that her children 8-year-old Cameron and 4-year-old Fabian were in the bathroom. And you can see on Detective Njoku's body cam, State's Exhibit 7, that she opened the door and they came out. They never left that bathroom once they were placed in it. And so the idea that a child had opened that door is just in stark contrast to the other evidence in the case and directly attacks the defendant's statement at trial. He also mentions that after he had shot, Vernice pushed him back. And he mentions how once he brings the firearm into the equation, all the other witnesses, despite common sense and reason of running away from someone with a loaded firearm, he mentions his mother lunging at him, Gregory coming to tackle him, and Vernice pushing him. The Vernice pushing him, again, something that is not present in his January 27th interview. Gregory Perez was clearly not shot. The children did not leave the bathroom once Vernice placed them in there. And people just don't run towards loaded firearms, they run away. And the reason these are all important is just because it attacks the credibility of the defendant who testified, because what he testified to is not reasonable with the other facts and evidence in this case. These key salient points, Your Honor, he had hours. This was not, malice can be formed in an instant, but in this case, there was much more time that did form. And it was a deliberate shooting. And other things that indicate the defendant's actions even after the shooting was he testified that he had 2 phones on him. He had his own phone, and everyone agrees that he took Vernice Headspeth's phone. And I would argue through the cross-examination of the defendant and asked him, and it is a reasonable inference from today's day and age, you can call 911 from a phone despite not having passcode. But nonetheless, he had his own phone that he says he realized, and he called his friend. He didn't call 911. He left the scene. He didn't attempt to render aid to Beverly Headspeth. And those are all consciousness of guilt and show that his actions, even after the shooting, he fled right away from the hotel with his sister's phone, where she had to call using another phone to get help to come. And he contemplated his actions, and all of those, Your Honor, go to the count 1 murder. That gives some insight into his state of mind. He also mentions, his mother was cussing at him right before he shot her, and that that coupled with his belief that she was poison to him, he had motive to kill her. And his actions did result in her death. And he could have told someone at the hotel staff. He could have, on the way out, stopped by the front desk and done any type of actions, or had his friend immediately call 911, but he did not. Those are his choices. It wasn't because he was not able to call 911 or try to get help. This is not self-defense. The facts and evidence are well and above beyond a reasonable doubt to disprove that assertion. It is necessary to prevent serious bodily death that's imminent. Even if you took the facts that he was being poisoned, that is not self-defense to take the law in your own hands and shoot and kill someone. He didn't even drink the Gatorade bottle or eat the food that he thought. That's his own testimony. In regards to the physical actions, when he mentioned that his unarmed mother, who his own testimony said was, already behind her better physical fitness days, she had no weapon and she didn't do anything. And he, as the second point, and things that are not legally self-defense, he's committing a felony aggravated assault when he is pointing the firearm at Gregory Perez. That's the first felony that is committed by the defendant. He's the initial aggressor in all of these situations, and all of those preclude him, therefore, falling on the sword of self-defense. And furthermore, it's a reasonable person standard. His subjective belief is irrelevant, quite frankly. And nonetheless, all of these things discredit and just dispute any assertion that he was legally justified to use self-defense. And it's certainly not reasonable to use deadly force when your unarmed mother comes at you. He mentions that Gregory Perez tried to tackle him or charge after him after he shot and killed Beverly Headspeth. That may have been a reaction in self-preservation, that unarmed Greg tried to stop someone who just discharged a firearm and moments before had the gun pointed at him. Nonetheless, there is no facts, and certainly the evidence beyond a reasonable doubt disproves any legal justification for self-defense. And even if none of these things existed, if he was not the initial aggressor, if he was not committing a felony, and if he tried to argue that he provoked them by pulling out the gun or confronting them and they attacked him, He started all of that. And furthermore, it's not reasonable, his actions. It's not self-defense. There was not an imminent threat of serious death or bodily harm. The best his mother could probably do at her age and fitness was push him, and he has the gun. So the state argues that self-defense is not legally valid. For the second count, felony murder, Your Honor, this is predicated on the count 3 aggravated assault. Obviously, if your actions when committing a felony result in the homicide of another human being, and there's a connection between them, it's felony murder. Malice, forethought, all of that is obviously not required legally. It is simply you are performing a felony which causes the death of another. There is a extremely direct correlation between the felony he was committing and the death in this case, because he was pointing his firearm at Beverly Headsmith, committing aggravated assault, shot at her, shot her, and that resulted in her death, as articulated earlier. It is a straightforward, the state argues, felony murder that was proved beyond a reasonable doubt. He admits to this act. He admits to shooting his mother, and Vernice witnessed that act. And clearly it was his handgun, his shot that resulted in her death. For counts 3, 5, and 6, I will break these down individually, but for count 3, I've just addressed that. The state argues that is clearly proven beyond a reasonable doubt with facts and evidence. For count 5, the state does believe that the facts and evidence in this case do support the aggravated assault on Vernice Headspeth that happened in the hallway. And I will break this down a couple ways. First and foremost, the evidence presented beyond a reasonable doubt shows from Jay Jarvis's testimony that the 9mm shell casing in the hallway was fired from the handgun the defendant had. And that's important for the next part of this analysis, which is if you look at State's Exhibit 47, that is room 318. And the placards, which are hard to see, but you can see the direction of the hallway that they're going. They are going down the hallway. And State's Exhibit 2 is just showing that spent shell casing. This hallway ends in State's Exhibit 39, which Terrence Clay testified to takes you outside the hotel. You would not pass by the front desk. With Vernice Headspeth's testimony, she saw the defendant after he took her phone, after she heard the gunshot, leave. And it's the state's position that it's reasonable to infer from this that he went out that stairwell, and that stairwell is at the end of the path where the shell casing is, where he was chasing Vernice Headspeth. And to break this down, this sequence of events, the state argues from reasonable inferences that can be drawn is what happened. Vernice, it may have been unclear, or she had just witnessed her mother being shot and murdered in front of her. She runs out of fear. She stated she was very afraid, and she knew that the defendant had a firearm because she just witnessed the music. She hears him running behind her. She doesn't see anyone else in the hallway when this happens. And he ultimately, I would argue, he's chasing after her. When he gets to her, he asks her for her phone. I would argue that when he's running behind her, they're going in the same direction. And I would argue that the gunshot that she hears, it would make no sense for him to shoot in a different direction when there's no one else in the hallway. And the state's position is that from someone who just discharged a firearm at his mother, was upset about what the people in the room were doing to him when he's chasing after his sister to get her phone, he's going to shoot in her direction. And the shell casing shows that he discharged in that hallway. The state would argue that there is a reasonable inference he was shooting towards in the direction of her. Where that bullet ultimately went is unknown, but the state would argue he is chasing after her towards the end of this hallway. Moments after he catches up with her, he gets her phone, and then she sees him leave. So this all had to happen down the same hallway. And it's, to me, if he's chasing after her, it is beyond belief to think that he shot behind him. And the state would argue it's not reasonable to shoot in the air or shoot on the ground when you're chasing after your sister to get her phone. And so I would argue that all of those happen in the same forward trajectory down this hallway. This is using reasonable inferences, which is legally allowed to get to this, because Vernice Headspeth did not actually see it, but she did testify to that she was very afraid running down the hallway. She just witnessed him shooting. And she also mentioned when she heard the gunshot, she stopped immediately and she was very afraid. And she had reasonable apprehension that when she heard that gunshot and knew him chasing behind her and he had a loaded firearm, of serious bodily injury. And this just articulates this. Furthermore, there's also the state would argue that when Vernice testified that she confronted him moments after she heard the gunshot and said, "Did you just shoot at me?" He did not agree or disagree with that statement, and which could be a tacit admission to that. And she asked him, "Did you shoot at me?" And I would argue that is also important to take into consideration with this. And Vernice testified that she didn't see anyone else in the hallway. And it sounded like from her testimony, it was a very brief amount of time between when the gunshot was discharged. She stops, he catches up with her and gets her phone. He was heading in her direction. For count 6, this is proven beyond a reasonable doubt in a multitude of ways, Your Honor. You have Vernice Headspeth who witnessed this with her own eyes. You have the defendant who repeatedly mentions in his interview and at trial that he pointed the firearm at Gregory Perez. There's no legal justification for that. He admits that fact, and his testimony about that and Vernice's testimony all lines up. There's no need for, with an eyewitness and a confession by the defendant, for Gregory Perez to testify to anything, because when someone's pointing a firearm at you, deadly weapon, that is aggravated assault, and anyone would have reasonable apprehension about that.
I pointed it at Greg. That's what I pointed it at.
And that clip, Your Honor, just is him stating that he pointed the gun at Gregory. For armed robbery, Your Honor, in this case, he obviously took Vernice Headspeth's cell phone. She testified it was an iPhone 7. He used that Springfield .40 caliber handgun, and he ran off with it. He later, he had testified and told, or not testified, but that phone was never retrieved. He does not have that phone, and Vernice Headspeth has never gotten that phone back, and he threw it away or left it somewhere. He had no intent to give it back. He fled the scene, and the state would argue that he probably took that phone as a reasonable reference to prevent 911 from being called, because he already had a phone on it. She felt that he may shoot her when she was asked on the stand what was going through her mind. He had, in the state's argument, for one, discharged at Vernice Headspeth's moments before, and he had the firearm on him. She did not feel like that was a voluntary request, and he had a firearm on his presence and took it from her. Furthermore, Your Honor, if the theft was completed after force was employed against the person, the conviction for armed robbery is authorized. He does not have to point blank put the firearm at Vernice Headspeth and demand that, given his actions immediately before this, taking her cell phone from her with a loaded firearm. The possession of firearm during commission of a felony. This is straightforward, Your Honor. Springfield .40 caliber handgun was what he possessed to commit the counts pertaining to Beverly Headspeth, which is the possession of firearm, count 7. Count 8 is the armed robbery and aggravated assault of Vernice Headspeth and Gregory Perez, count 9. That was a firearm that he possessed when he committed those acts. The cruelty of children in the 3rd degree, Your Honor. Knowledge that a child, he, in his interview, stated that he was aware those children were living there. They were there for a month. He testified that they were in the room when he pointed the gun at Gregory Perez, and they saw him commit the aggravated assault, which is a forcible felony, at Gregory Perez by pointing that firearm at him. He was, of course, as the cruelty of children statute, he's the primary aggressor. He has knowledge, both visual and actual, from just seeing the children in the room, and they're present. Vernice Headspeth testified to their date of birth, and they were 8 and 4 years old at the time. She said Cameron was either 8 or 9 and Fabian is 4, and with their birthdays, they were certainly under the age of 18, and they saw the act, and it prompted Vernice to go put them in the bathroom after that. And this body cam clip is simply to establish these are Cameron and Fabian that were in the hotel room after Detective Njoku. This is her body cam, states that at 7, letting them out. Vernice Headspeth testified, and the defendant testified to them being present. And Your Honor, the state would argue that all of the charges in this indictment have been proven beyond a reasonable doubt. And I have articulated the facts and circumstances and the reasons behind that. I think the strongest evidence in this case is the defendant's own words. The consistencies between what he told Detective Williams and what he said on the stand, and importantly, the inconsistencies give clarity and insight into his state of mind, which is relevant for murder. And he admits to the elements himself for the felony murder and the aggravated assault of his mother. He denies shooting at his sister, but he does not deny taking her phone. And I would argue that Denise Headspeth testimony proves the armed robbery and aggravated assault against her with the other circumstantial evidence addressed. Certainly the Gregory Perez count 6 from the defendant's own words and the eyewitnesses. And I've already articulated count 7 through 9, possession of firearm during commission, and that the children witnessed a forcible felony when he committed the count 6 aggravated assault on Gregory Perez. And for those reasons, Your Honor, the state would argue that his actions that day were proven. There was no self-defense. And I would also argue that there is nothing in his actions that day that give rise or legal voluntary manslaughter. This was a calculated decision that he made without any provocation, and it's a reasonable person standard. His actions that day were not reasonable. In his use of deadly force, his use of pulling out the firearm in a motel room, he did not testify to any physical actions that Gregory or his mother had done in the moments or that day before, and none of his actions were reasonable. And he intentionally caused and committed these acts beyond a reasonable doubt, Your Honor.
All right, thank you, Mr. Atkins. So I was waiting until both sides had had a chance to make their closing arguments before reviewing that interview. So as I understand, it's about 40 minutes in length. So I'd like to go do that now. And why don't we reconvene at 10:30? All right.
Yes, Your Honor.
Thank you.
Can I go back there?
Who's your investigator on Mr. Atkins?
It's Walker. You say where he is or who is it?
Oh, who is he? Yeah. I don't want to have that gun.
That's fair. He's tall.
What's his first, to keep the full count, right?
Yeah, it's Dejan Walker.
Okay.
J-A-J-U-A-N.
Okay.
Yep, his hat's here, so.
Okay.
I'm not gonna go further. I'm gonna get some water.
How you doing? How you doing?
We got a small bottle.
Of course.
Sorry, what did you say about the gun? I was gonna ask you about the evidence. I know we just got the order. So did you bring it out or can you run down, get them?
Well, you don't have to, I'm working it later on.
Sure. I need to know. I do, I was told that there's first the order that was signed, and then there's forms that we give to
Right.
both sides, just to let them know, hey, we are not handling those exhibits. We make them all, that's all.
Okay, so there is a.
All right, welcome back, everybody. I did have a moment to, and took the time to review the submitted interview in this case and to consider the testimony and evidence presented yesterday, as well as the closing arguments by counsel. Although it's obviously not something that we would ever hear formally on the record in a jury trial, I do think that in this context, it wouldn't be inappropriate for me to offer a few observations on the finding of the court, with the caveat that obviously this isn't I'm not about to lay out the sum total of every consideration of every piece of evidence or explain every nuance or everything that went into the decision, but simply convey an executive summary, and not exploring every factual legal possibility here. But essentially what I wanted to touch on was that, as was argued by the defense in closing, the law should be flexible in situations and in a scenario. And in looking at that, I believe the law does allow some level of flexibility in self-defense, and that's where we have the reasonable person standard. And not only are we supposed to consider the subjective thoughts of a defendant, but there also must be an objective test. And it's not purely an objective test, because otherwise we wouldn't be, because we are the fact finders allowed to consider such things as prior difficulties between the victim and the accused. They're allowed to consider physical differences between the two, showing that there is some subjectivity to it. The Supreme Court has noted, however, that subjective fears of a defendant are irrelevant regarding third parties. But as I mentioned, there is some level of subjectivity there, and where that line is of what is considered a reasonable belief and a reasonable person is kept somewhat ambiguous in our jury charges. So I do believe that the law and the common law does allow some level of flexibility. And the bottom line here is that the question becomes whether I think even without reaching any conflicts in the testimony, just considering Mr. Headspeth's testimony on its face, and even believing this possibility that his mother was poisoning him, the question is whether the mother's unarmed lunge justified deadly force in self-defense. And I believe, after considering it, that it fails on several levels. There was the evidence here was, and following our jury instructions, that this response, the defendant's response, was not that the force used in response to a lunge, even if it did occur, was excessive. And then we reached that objective requirement, which again is there to prevent 10 million different personal definitions of self-defense in Georgia, that it was not a reasonable belief in response to the situation being faced. There are also the considerations of that the defendant initially was the one to provoke the force, the initial aggressor. And there's also the charge to consider that, again, even assuming that the poisoning was present here, that revenge is not something that's allowed in the law, and the nature of a poisoning itself is not something that demands immediate self-defense like this. So those are just a few reactions among many to this evidence as presented. And so to that end, I believe the state did prove beyond a reasonable doubt that there was sufficient evidence to convict on each of the charges in this case. And so I've prepared a verdict form reflecting as much, and counsel can review it. If need be, I've marked it as court's exhibit.
Thank you, Judge.
So with that disposition being entered, is there anything we need to address from either party, or any reason we should not proceed into sentencing in this case?
No, Your Honor, the state is prepared to proceed to sentencing when the court would like.
Mr. Marks?
Yes, Judge, we can proceed today with sentencing since all the parties are here. I'm prepared for this potential outcomes, and that's why we're ready.
All right. In that case, Mr. Atkins.
Yes, Your Honor. So state for sentencing in this case, given this court has heard and has pronounced the thoughtful review of this evidence and the facts and circumstances, and the state's position on, or I'll state what the state is requesting and then explain why. And so in total, Your Honor, the state, as like the ultimate sentence, is life without the possibility of parole plus 20 years to run consecutive to that. And the state is requesting on count 1 murder, life without the possibility of parole. In this case, the actions of murdering your mother and also the other counts involving a firearm at Perez, shooting at your sister, committing an armed robbery on her, that also involved an 8-year-old and 4-year-old witnessing this, is a callous action that resulted in the loss of life and a tremendous amount of pain and sorrow from the families. And that level of actions by the defendant warrants a life without the possibility of parole on count 1 murder, due to, in the state's position, those actions that were not predicated on, there was not mitigating circumstances behind those actions of the defendant. And for count 2, Your Honor, felony murder, that would vacate as a matter of law. Count 3, aggravated assault, would merge into count 1. Count 4, the armed robbery, the state would recommend or request the defendant be sentenced to 15 years consecutive to count 1. And for count 5, the aggravated assault with a deadly weapon, 15 years consecutive to count 1, concurrent with count 4. And for count 6, the aggravated assault, 15 years consecutive to count 1. And for all the possession of firearm during commission of felonies, to be 5 years consecutive to the predicate felonies. And to run the possession of firearms, the intent of the recommendation of the state is to run concurrent with one another for a total of 20 years consecutive. And the state, regarding the counts 10 and 11, would be 12 months confinement concurrent with count 1 murder. And Your Honor, the state would also like to permit this. So Carolyn Tyus, my victim advocate, has a statement presented by Shawana, who is the daughter of Feliciano, who is the daughter of Miss Beverly Headspeth and the sister of Vernice Headspeth and John Headspeth. She has a medical appointment this morning, has been present at the trial, and is actually trying to watch if she's done that on Zoom. But the state would like for Ms. Tyus to read that. And I also would have after that, Ms. Andrea Williams wanted to read a statement on behalf of Vernice Headspeth, just due to the emotions of that, Your Honor.
Good morning, Your Honor. I'm Carolyn Tyus, the victim advocate for this family. On behalf, and this is from Shawana, and she did it on behalf of her whole family still. On behalf of our family, we pray that justice for our mother, sister, and grandmother is served today. Beverly Headspeth, a 62-year-old gentle soul, life was cut short by the hands of her one and only son, John Headspeth. My mother had so much more love and life to offer. She had plans to see her grandchildren grow up and to become young adults. Our mother was one of the most kind, humble, meek, loving, and caring person you could ever encounter. She was a peacemaker and never a threat to anyone. All we have left are the great memories of her, and our hearts aches for her daily. John Headspeth not only murdered his mother, but he has demonstrated that he has absolutely no remorse for doing it, and this really concerns me. He makes no apologies for his actions. I feel that he is a menace to society and that he should not be allowed to be free to cause this pain to anyone else. So I'm humbly asking that the court give our family the justice they deserve. Thank you, Judge.
And Your Honor, the state would also have Ms. Williams come up to speak on behalf of Bernice Headspeth.
Yes, I'm Andrea Williams, a longtime friend, 20 years of Bernice Hespeth, the daughter of Beverly. And here. Yes, I'm Andrea Williams, a longtime friend of 20 years of Bernice, the daughter of Miss Beverly. This incident have caused a lot of traumatic to her and her children. They suffer daily, very restless. The children are not children anymore. They don't play as if they normally would. And, she's trying to move forward, and it's very difficult because she was a very big part of her mother.
Thank you, Ms. Williams. And Your Honor, in conclusion, the state would just like to address that the evidence at trial about the firearm jamming, in terms of this could have had even more tragedy than it had, in terms of I think that should be noted in sentencing in terms of the intention from the defendant's testimony to shoot Gregory Perez, and that gun had malfunctioned. And also the fact that the firearm was discharged a third time in the hallway in the direction of Bernice Headspeth is relevant and pertinent to the life without the possibility of parole, given to that significant dangerousness alone for discharging a firearm at 3 people separately in a short span of time.
So Mr. Atkins, can you describe to me whether there's any evidence or anything in the way of a prior history? Was this Mr. Headspeth's first arrest?
So, Your Honor, he does not have any adult history. And there is, I don't have any adult convictions, misdemeanor or felony for the defendant. And I had there's no adult history. The reason I don't know what the final disposition was, if any, and I don't know if Mr. Marks knows, but there was an incident in 2001 involving his sister who drowned in a bathtub. She was 3, or his niece. She was 3, he was 11. And I don't want to get into that right now, but I don't have a juvenile conviction of that, but he references this in part of his statement in terms of, I will leave it at that, Your Honor.
All right. And did the members of the family express, I've heard in their statements, did they express any opinions as to what an actual sentence would look like in this case?
Your Honor, they have not directly expressed to me in terms of numbers of years or life without the possibility of parole. I did explain that this requesting life without the possibility of parole, but if the court would like, I could inquire, but they didn't have recommendations specifically onto that.
All right. Okay. Thank you, Mr. Atkins. Mr. Marks?
Hey, please the court. My client represents as follows. He is 32 years old, has an 11th grade education. He was working in the past for UPS, at a warehouse, at Publix, various places like that. He's a lifelong resident of the Metro Atlanta area. I have not been given permission from my client to provide any information to the trial court concerning any mental health history. I will note, however, that my client did testify about his belief that his mother was poisoning him, his belief that he was being poisoned at the Fulton County Jail. It is the defense's contention that there were certain factors that impacted how my client sees and perceives reality, which I would contend constitutes a mitigating factor for the trial court's consideration. Secondly, the other thing that I would underscore is the fact that my client did testify on the stand that he felt badly about what he had done. And the defense would contend that he, in doing so, showed an element of remorse. I believe I asked him a couple questions to that end, how he feels bad about that. He wish he hadn't done it. So we do have some contrition expressed, and we believe because of these factors that the defendant, we're asking that Your Honor sentence the defendant to the minimum allowable by laws to each count. And we know that the minimum when it comes to the murder counts is life, as opposed to life without possibility of parole. So that's what we're requesting. Thank you.
Well, Mr. Marks, one more thing, just since you touched on it. I understand you're not authorized to provide any additional details in mitigation. However, just from a professional standpoint, I would inquire, are there any observations you've made during the course of this trial as it comes to your client's ability to assist in the trial or his general competency to understand the nature of these proceedings?
I have no reason to believe that my client is not competent to stand trial. I believe he is competent to stand trial. I haven't noticed anything during the course of the trial that would lead me to believe that competency was an issue. My client was evaluated twice. First by Grady, he was found competent to stand trial. We retained a private psychiatrist who also concluded that he was competent to stand trial, and I have no reason to question that.
This evaluation by Grady, was that part of the record through a ex parte request? I didn't see that reflected in the record in the usual means we would do that.
I believe I have a copy of it, but I'm not sure exactly how.
Well, I don't think I'm saying it would be appropriate to make it part of the sentencing, especially since you're saying you are not tendering it.
Sure, I understand. And my understanding is that when we do these ex parte Grady competency evaluations, they are delivered to the court and to the defense counsel and not to the state, unless the defense files a special pleading of mental incompetency. Then the state is statutorily entitled to retain its own expert.
And I think that's absolutely right. I may have missed it on the docket, so I just wasn't aware.
Judge Glanville. So this evaluation was dated November 16, 2022, and because of the nature of the competency evaluations through Grady, which is different than when you retain a private psychiatrist to do the evaluation. When it goes through Grady, they go to the trial court and to the defense lawyer if it's ex parte. In some instances, it goes to the state. But I do have the evaluation here, and I'm not of the opinion that you would be barred from looking at it since it went to the trial court, Judge Glanville. But my client doesn't want me to release information on the record concerning his mental health history, and I've decided to honor his request. But I do believe, in answer to your first question, that there are no competency issues that I observed and that were observed, and that Grady cleared him when it comes to that issue. Psychiatrist that we retained, Dr. Smith Bandari, cleared him when it comes to that issue. That doesn't mean just because someone is found competent to stand trial doesn't mean that a particular individual doesn't have any issues. But I didn't see competency as an issue that warranted additional investigation on my end.
All right, understood. Thank you for that. And again, I think if it's not being made part of the record at this phase, I haven't read it. And I don't think unless it's tendered and introduced so the state could respond to it, is likely something that's fair game for me to even consider.
Right, I understand that. And because my client has explicitly told me not to release that, I'll just check with him to see if he's changed his mind. My client has indicated to me that he wants me to provide the state and the trial court with a copy. Although this is all I have.
Let's mark that as an exhibit then, and also make that part of the record. And these are, what is
I could
this?
just get a copy of my file at some point. I only had 2 copies.
Right.
So, but at any rate, the defense would contend that the information contained in this Grady evaluation can be deemed to be considered, at least potentially, as mitigating factors for the trial court to consider and to exercise its discretion accordingly.
All right, well, let's take a minute, hold in place, and to allow everyone the chance to review it, and I'll give my copy to the Ms. David to make part of the record. I hadn't marked it, but we'll just make that, we'll make the evaluation tendered by the defense courts too.
I'm sorry, Judge.
Did you already mark an exhibit, or should I just make this courts too?
Oh, if you could do that, then
All right.
thank you.
I didn't bring any out, no. Okay. And then I think just as a matter of housekeeping as well, is there any need for me to formally publish the verdict as to each count on the record? Or is the defense willing to waive that at this point?
The defense is willing to waive that at this point.
All right, and Mr. Atkins?
No objection with that from the state, Your Honor.
All right. So having reviewed courts 2, which was tendered by the defense, Mr. Atkins, was there anything else, Mr. Marks, that you wanted to present?
No, Your Honor. Thank you.
All right, Mr. Atkins, anything else that you want to raise in response to that or respond to?
No, Your Honor.
All right, after considering the arguments of both parties, I believe there is something of a trade-off here. I think the state has, in proving its case, shown that the facts are particularly egregious as it comes to the presence of young children, the presence of multiple victims, and again, as stated by the evidence, the really unnecessary and unprovoked nature of what occurred. On the other hand, I think there is some mitigation here with the lack of any adult arrest history. I think that is a very important consideration in these, obviously it's sentencing. And I think what's presented in defense too is more of what was alluded to at closing, that there are just many unanswered questions here of exactly what happened, what motivations occurred, despite the fact that the facts, there really isn't a question of what did happen. And it's also a bit of a tricky situation here where, yes, we're on the other end of a trial where the defendant wouldn't be entitled to the traditional acknowledgement of acceptance of responsibility. However, obviously, just with the posture of how we got here, that's a little more nuanced. So ultimately, where I feel that a life without parole sentence could be warranted on these facts, I think there is sufficient mitigation to suggest that's not entirely appropriate here. And so I believe the global sentence that I would be announcing today would be a life plus 20 years. And the way that would break down would be on count 1 as to murder. The sentence would be life. Count 2, felony murder, would vacate by operation of law. Count 3, the aggravated assault, merges into count 1. Count 4, the armed robbery, I believe the sentence could also be life concurrent with count 1. Count 5, the aggravated assault as it relates to Miss Vernice Headspeth, the sentence would be 20 years to serve consecutive to count 1. Count 6, the aggravated assault as it relates to Gregory Perez, would be 20 years concurrent with count 5 and consecutive to count 1. The counts 7, 8, and 9, I believe, stand because there's allowed to be 1 for each victim listed in the indictment. So those would all be 5 years consecutive to each other and consecutive to counts 5 and 6 to run suspended. And counts 10 and 11 would be 12 months to serve concurrent to count 1. Any issues or clarifications needed on that sentence as pronounced?
No, Your Honor.
Your Honor.
Anything else we need to take up on this matter?
Not from the state, Your Honor.
Not from the defense judge. And just for the record, I did discuss with my client the appellate procedure from here on out.
No, I need to formally advise him of that. So if we could hold in tight, let me make sure I get the exact language.
Okay.
All right, Mr. Headspeth, I have a few things I have to advise you of now that we're at the end of this trial. You have the right to seek post-judgment relief from your conviction of these crimes, either by making a motion for new trial in this court and or filing an appeal to a higher appellate court. If you want to file a motion for new trial or an appeal, you'll need to file that motion or notice of appeal with the clerk of superior court in this county within 30 days. You may want to more fully discuss this with your attorney. If a motion for new trial is made and the court denies it, you'll have 30 days from the filing of the order of denial in which to file with the clerk of court your notice of appeal. You also have a right to an attorney to represent you on the motion for a new trial and the first level of direct appellate review. And if you cannot afford an attorney, the court will provide you with an attorney and a transcript of your trial at no cost. Because these are felony convictions, you have a period of 4 years from the date that your sentence in this court becomes final to file a habeas corpus petition. Is there anything further, Mr. Atkins, to have on the record?
I do not believe there is, Your Honor.
Okay, Mr. Marks.
No, Your Honor. Thank you.
All right. Good luck to you, Mr. Headspeth. And court will be adjourned.
Your Honor, I'll wait here so that the close can be brought up. I'll bring it back to the office. May I approach?
Card back.
Was this the profile on her?
Yeah,
I couldn't get past the paywall,
there you go.
so I appreciate you bringing that.
Sure.
And
I need to be alone. Right.